All right, let's go ahead and get started. My name is Jason Shade. I'm an attorney up in Johnson City, Tennessee. Been practicing for about 20 years. My practice primarily focuses on, well, probably about 60-70% is real property and construction litigation. Of the construction side of it, probably the majority of it's residential construction, representing both owners and contractors. Today's presentation is just a construction contracts primer, and looking out in the audience here, I think this is probably going to be well below everybody in the room here, so bear with me. It was premise was supposed to be for the new attorney, so a lot of this you guys probably already know, but we're going to wade our way through it this morning. The way I tried to set this up was went through just a garden variety construction contract, tried to pull out some relevant provisions and try to discuss it. I tried to put some sample language up there that you guys may or may not be able to use in your construction contracts. I did not, I probably should have. Looking back, I've got a boilerplate construction contract that I use. It's pretty basic. If anybody would like a copy, although just looking, I don't think anybody needs a copy of it, but feel free to email me and I'm happy to send that to you as well. Starting off, just obviously the different types of contracts you may have in a construction context. It's not advisable, but I've seen oral contracts come down the pike for the construction of houses. I had a client come into my office that built probably a $700,000 house a couple years ago with no contract whatsoever. Most folks that come in, they'll say they don't have a contract, and I guess my response is, well, you probably did have a contract, it just wasn't written. So, all you really obviously need is offer acceptance consideration, and off you go. In that particular case, that gentleman built probably like $650,000, $700,000 house. He wasn't a licensed contractor, which compounded the problem. Oddly enough, there were really no disputes for workmanship issues. $700,000 house, no, that wasn't the dispute of the lawsuit. It was merely just payment disputes, probably because they didn't have a written contract, among other things. But again, you can have oral contracts. It's not advisable. I don't see it on a regular basis, but it is possible. Written contracts obviously is the norm. You need to be paired by either a contractor or a homeowner. In my practice, I've seen contracts that, a 2-page contract up to, 10, 15, 20-page contracts before. I think obviously I represent a lot of mom and pop contractors, and so if I banged out a 20 or 25-page contract, for the construction of a house, they probably would look at me like I'm from another planet. So I think you obviously know your audience. I've represented folks that are doing, farmers up in Upper East Tennessee that are fairly wealthy, and they come in and you draw up a contract, and I had a client tell me one time that he wanted a contract on a 7-figure deal to be less than 3 pages, and so I just kind of looked at him and I was like, I don't even know how that's possible, but we did our best in that regard. Obviously, it's going to vary between the project as well as the parties to the contract, like I just mentioned. AIA contracts, you guys are obviously familiar with these. They are produced by the American Institute of Architects. Most widely used standard form contracts in the construction industry. Obviously, they're going to get advice from owners, engineers, attorneys, architects, contractors. Most of those documents are fairly even-handed. Obviously, they're not going to favor one particular party over another. For whatever reason, I don't see a lot of these in the residential context up in Upper East Tennessee. Do you guys see a lot in the residential context down in the larger cities?
A lot, the AIA has a form for small projects or residential.
Right.
That's not a bad form. It's much smaller than their A2O,
right,
all that other stuff. And I see some of those, but most builders in our neck of the woods have their own forms that they've stolen from somewhere else.
Right. Yeah, exactly. So, and to Tim's point, I try to, and I don't know, I tried to go in and pull up a couple form document numbers there that may be of some benefit to you. Again, probably in the past 5 years, I've seen 2 maybe come across my desk on a custom project. So I just don't see them a whole lot. Parties to the contract, again, what seems to be a very basic concept may not be in actuality as far as when you start preparing the document. If you're a contractor, I've had contractor clients come in before, say they're going to build a house on a piece of property. You pull the tax card, do some title work, whatever the case may be, and come to find out that the person you're building the house for doesn't even own the property, which could be a real issue. This happens a lot. Again, I see it a lot more so, out in the counties and whatnot. Mom and dad will own 30, 40, 50 acres of property. They're going to carve out 2, 3, 4 acres for their son or daughter to build a house, and then you go look and son or daughter doesn't even know the property. So there may be some backfill work that you may have to do before the construction even starts. If you're an owner, as far as checking out your contractor, I don't want to get in Tim's segment. He's going to talk about licensing, but your contractor license, obviously, more than $25,000 worth of work. It is a high-level analysis. I see this a lot too as a contractor attempting to operate under another contractor's license. Again, that's quite prevalent up in Upper East Tennessee. If a contractor is not licensed, they're going to try to piggyback onto somebody else's contractor's license. A lot of times contractors think that they're licensed, or if they're incorporated, they're an LLC, they're going to have that on their documents or initial correspondence. You go look them up on the Tennessee Secretary of State and they're nowhere to be found. They're probably in partnership or whatever the case may be. If you are requesting insurance documents from the contractor, make sure that the name they're contracting with is obviously what's on the insurance docs that you're receiving for insurance purposes. Scope of work, there's a sample provision here, and again, it's very basic. Contractor will furnish all labor, equipment, materials, building permits, transportation, supervision, coordination, communication, shop drawings, storage, workmanlike manner. Typically, if it's a reno project on a house, that's probably something you can probably fill in with 2 or 3 lines. More times than not, you're going to see attach an exhibit as far as what actually the scope of work is. Obviously, it's a short, concise statement summarizing project descriptions. Clarity is the key here. I think you want clear expectations between, the owner and contractor as far as, what's going to be built, when it's going to be completed, those sorts of things. Obviously, it's going to lay out the owner's expectations for the completed project as well. It's going to be, again, clarity is the key. This should be a collaborative effort between the owner and the contractor as far as them working together to try to figure out, the best result for the project and how they're going to get from beginning to end. Property boundaries, in my contracts, I have a property boundary section. Again, owner will supply contractor with a legal description of the property. If requested by contractor, owner will supply contractor with survey, boundary stakes by a licensed land surveyor. Again, this is probably not as a huge issue if you're building a spec home in a neighborhood that's already, platted out. Again, up where I practice, you see this a lot where you could have a legal description that's 3 or 4 pages of meets and bounds description. So I think it's important for the contractor, to get the property description from the owner. If and to the extent there turns out to be some encroachment issue down the line, I think that would benefit the contractor in that respect that the owner provided that information. Subdivision requirements, again, I don't know, you guys may not see this a lot in larger cities, I don't know, but again, going back to the scenario with mom and dad carving out property for their son or daughter, if you have more than 5 acres, say you've got a 40-acre tract and you're carving out less than 5 acres, that's going to need to be approved by the planning commission in your local jurisdiction. And so that may or may not be an issue. And the problem with that is if you start carving out less than 5 acres, up in Washington County, for example, if it's less than 2 acres, you're going to have 25 foot of road frontage. More than 2 acres, it's 40 foot. I had this issue come up with a contractor client last year, as a matter of fact. Same scenario, mom and dad was giving son some property. Well, come to find out, they plan to use the same access road for the main house. They couldn't get it through the planning commission because they didn't have the road frontage for, the 2-acre carve out that they were trying to do. So again, something to keep in back of your mind as far as you represent contractors, that this may or may not be an issue if you get out in the more rural areas. Drawings and specifications, again, sample provision. This project will be construed according to drawing specifications which have been initialed by the parties and which are hereby made a part of this agreement. This agreement, drawing specifications are intended to supplement each other. In case of conflict, however, the specifications shall control the drawings and the provisions of the agreement shall control both. Obviously, the drawings and plans, it's a set of scale drawings, obviously, that show the contractors what they are building. The specifications, on the other hand, are a written document that details the materials to be used and how to install it. A very basic example, drawings and plans may have a vanity with 1 sink, whereas specifications, may have a vanity with 2 sinks. Well, in that particular case, if, the specifications will control. So I think it's important to put some clarification language in there as far as what's going to control if conflicts do arise between those particular types of documents. Time for completion of work. I think as we go through some of these provisions today, some of these are more fertile for litigation than others. Obviously, time completion for work is one of them. Change orders is probably another. As far as the contracts you provide for completion by a certain date or within a certain period of time, again, legal issues obviously come up. It's fertile ground for litigation. I think if you're looking at preferences between an owner and a contractor, the owner is going to want a set period of time for their house to be completed, obviously. Most construction loans are 12 months, typically. And so the owner is going to want their house to be completed within that 12-month period. Obviously, on those construction loans, you've got interest only a lot of times for that 12-month period on the construction draw. If it's not extended, the bank is not gracious enough to extend it past that 12-month period, then that's going to convert to a conventional P&I payment. And so, which, if you have an owner that's building a custom and they're barely able to build the $750,000 dream home, and all of a sudden that's converting over to a P&I payment, and they're still living someplace else and haven't sold that other, whatever the case may be, it can create some issues for sure. Owner's going to want to ensure that there's some language in there that that the completion time is not going to be extended for malfeasance or some sort of negligence, if you will, on the part of the contractor. Situations can arise, if a contractor, needs that they're going to need a piece of equipment or certain materials to complete the job, and they're just, negligent and failing to order it within a particular period of time, where obviously the owner is going to want some language in there to protect themselves on that. On the other hand, owners should have a realistic completion of the time schedule. Obviously, projects are going to move along a lot faster, or they should, spring, summer, fall months than they will the winter months for obvious reasons. Contractor preferences. I don't know of any contractor, at least mine, that want a set time frame within which to complete a project. If and to the extent this is a issue of deep conflict between the owner and contractor, obviously, and there probably should always be a situation where the contractor is going to put some language in there that's going to give them an out, for acts of God, labor shortages, material shortages, whatever the case may be, that they have an out if and to the extent it's not the project's not completed within a particular period of time. Obviously, the contractor is going to want some language in there too that if the contract isn't completed, and that's on the fault of the owner, that there's some language in there that protects the contractor on that front as well. If you got an inexperienced contractor and they just don't really know, how long it may take to build this particular type of structure or house or whatever the case may be. You know, have them talk with a more experienced contractor. I've done that before, just so we can you know, wade through those issues as far as completion times and the like. How do you define completion? You know, no, another fertile ground for litigation. Obviously, you know, it's probably completed for its, you know, it can be used for its intended purpose. You know, in the residential sense, that could be the CO, certificate of occupancy. You know, maybe not in construction, or excuse me, commercial projects. You know, Jerry talked a little bit about this. I mean, you know, if you've got a owner that's building a hotel and the interior rooms are finished and they can actually, you know, allow folks in to sleep overnight, you know, that's the intended purpose. That's what a hotel is, but that doesn't necessarily mean, you know, if the landscaping's not finished, the lobby's not finished, the restaurant's not finished, that it's actually substantially completed. So again, that's another fertile ground for litigation as well. If and to the extent, you know, there's a contract that has a time extension provision, and just not just construction contracts, but just contracts in general, make sure your client's just following, you know, what they need to do. If they need to provide notice by certified mail by X amount of time, you know, or a certain date, then have them do it. You know, I hate, although it's becoming more prevalent, I hate having email notice provisions in contracts. I think it's, you know, for obvious reasons. I don't, you know, one, a lot of people don't read emails, you know, they should, but, you know, we get inundated with them on a daily basis. And two, a lot of, you know, I'll get 25 emails a day about investing in some African scam and trying to give people money, but emails from clients somehow end up in my spam folder. So I haven't really, you know, quite figured that out. But, you know, again, as far as the time extensions and the notice, make sure your clients are just, you know, following through, doing what they're supposed to do on the notice provisions in a particular agreement. A very basic provision here. You know, this is just one I pulled out, you know, that after the execution of the agreement, owner will have the job site ready for commencement of construction and shall give the contractor written notice to commence work. Contractor shall commence work within so many days after such notice and shall complete the work within so many calendar days. Obviously, we probably can read that one paragraph and see, you know, 25 different issues that can come up with that. But, you know, again, you know, it's a place to start as far as, you know, at least having some sort of timeline when things are going to get started and completed. The companion clause that I was talking about earlier, if there is a fixed time frame in a contract, which again, most contractors don't like, this companion clause, again, is something that can be inserted, and there's probably additional language as well. But, you know, the contractor will be excused for delay in completion for acts of God, acts of the owner, inclement weather, labor trouble, acts of public agencies, inspectors, public utilities, extra work, failure of the owner to make progress payments promptly, or other contingencies unforeseen by the contractor and beyond the reasonable control of the contractor. Again, it's one of those scenarios where you want to allow the contractor an opportunity to at least have an out if, you know, the house, for example, the $1 million home that he's building is not completed within a particular period of time. Payment on the project, there's obviously many different variations for this. I tried to go through and just pick out two that I see frequently, and it's obviously the cost plus contract and the fixed price contract. You know, the cost plus is basically, you know, it's going to be the cost of the project plus, you know, the profit margin. You know, typically the profit margin is going to be, at least that I see, 10, 15, 20%. So the cost is going to be the material, labor, overhead. The contractor is going to know ahead of time. They're going to factor all that in. It's going to be the cost. And then, you know, the extra 10, 15, 20% is going to be, you know, their profit. Obviously, if you got an unlicensed contractor, again, that could cause some issues about what they can actually recover, you know, if they are unlicensed as well. Fixed price, obviously, it's what it says. The contract is going to the project's going to be constructed for a fixed price. There's pros and cons to both of those. Obviously, I think in the residential sense, I think a homeowner is going to want a fixed price contract, obviously. I mean, they know what they're getting for a set amount of money. I've had some contractor clients recently tell me that they're just not building custom homes anymore, especially with the margins that they've had the past couple years and the profit that they're making. They can go in, they know on a spec house, they'll go in and buy 5 lots in the neighborhood. They'll come in and, put the footers down, the framing crew will come in, and they'll just go right down the line and construct, 5 houses. They'll do it for a set price for each house. They know ahead of time what their margins are, what the fixed price is. They know from experience that they're going to make a certain amount of money on each project. So again, I think a lot of contractors these days don't mind fixed price contracts. I mean, you still get the issues with change orders and the like, but for the most part, again, there's a lot up in my neck of the woods that aren't even doing custom homes anymore. They just don't make the money that they will on a fixed price spec home. Cost plus, obviously, there's not a downside to that if you're a contractor. I mean, the project is what it is. So, back in the day, I think, you used to see a lot of contractors using cost plus contracts, and they still are, especially on the customs that they're doing. A lot of times that may not be a bad deal for the homeowner as well. I mean, obviously, if you get in a fixed price contract, the contractor may put lower grade materials, finishings in the house for the fixed price to increase his profit margin. If you're doing a cost plus scenario, obviously you can control the finishes and the detail that you're putting in the house. And if you've got a client that's building $1 million plus home, then they know they're already spending a ton on a house, so they may not mind the cost plus scenario. So obviously cost plus contracts can face disputes over price calculations. See that all the time. Payment for the project. General considerations here is just be consistent. And I was preparing this presentation. I had just about 2 weeks ago, I had a client come in, moved here from California, bought a farmhouse. They're renovating it, hired a contractor who, oddly enough, wasn't licensed as well. But in this particular scenario, the contract that this contractor was using, it may have been one pulled off the internet, I'm not sure. It was fairly detailed, but he went through every stage of, the master bedroom, bam, this is what I'm doing. The master bathroom, this is what I'm doing. Well, after every one, he put estimated cost for work described, and this was the last one that is cut and paste. It was $12,460. Well, if you come down here, you can see the contract price that he has. The owner will pay the company the fixed sum of $102,363. So, I mean, obviously, are you dealing with a cost plus scenario or, a fixed price contract? Obviously, I'm representing the owner in that situation, so I'm going to argue it's a fixed price. But again, just be consistent, in the terms that you're using in your contracts, because obviously, if there's an ambiguity like this, it can create some issues. In this particular case, they did amend it. Job actually went up to 120, but project went over to 150. My client asked, how much more work? Contractor said about $10,000 worth more of work. Come to find out, they got popped with a final bill of about $50,000. So a $120,000 contract ended up being a $200,000 job, which my clients are not too terribly excited about at this point. So,
they're excited.
Yeah, exactly. Not excited to pay it, but yes, their blood pressure is elevated for sure. So, good point. Again, estimates. I've had a couple cases with these estimates, even on cost plus contracts. Can lead to litigation, and I think you have to be careful if you're representing a contractor you know, how to protect the contractor in this regard. I don't know, you guys may have seen a lot of this too, but it's a situation where it's a cost plus contract. You know, contractor's going to say, you know, it's going to, you know, $150,000, $200,000, whatever the case may be. Well, it gets in and it's, you know, a lot more for a lot of different reasons. It could be change orders. It could be just the contractors, you know, ripping the owner off. I mean, it's hard to tell. One thing I'm not saying it's bulletproof. I have started to try to use some language. And there's probably different variations you can put in there, but, you know, if there's an estimate, I've been trying to put some language in. The scope of work shall consist of the categories of work described on the estimate attached here too. The estimate is attached solely for the purpose of describing the category of the work. The pricing on the estimate shall have no bearing on the cost of the work. You know, I'm at the point now where I'm putting that in bold, you know, like a liquidated damages provision. I'm putting a little underline there and making, you know, the owner sign it, at least to give my contractor clients some protection, you know, if and to the extent it is a cost plus, estimates are involved, you know, that you can fall back on that at a later date. Yes, sir.
I have a situation where the cost, well, it's just like what you showed.
Mm-hmm.
It has both in this contract, cost plus and a fixed cost.
Yeah.
So, you know, what kind of contract we have. But also, the contractor said he was billing a flat amount every month of like $1,200 because for what he line item as the job foreman, for him being the job foreman. And he said, well, I didn't hire a job foreman, but I was performing that duty.
Mm-hmm.
And he put $1,200 or $1,500 each month. And I'm like, wait a minute. No, but he wasn't on the job every day.
Yeah, yeah.
And I don't know, the decision I took is, no, you don't get, that's double dipping, basically, is what I think.
Yeah, and I think most, at least the judges I practice for, probably would say the same thing. I just don't think that, you know, would be considered double dipping, in, you know, in my opinion, as far as that goes. So,
I think that goes into, and it's a problem because there's really, while there are certain items that most contractors and most construction organizations like ABC and AGC would agree are part of overhead, there's no real definition of that in the world. And so every contractor kind of has their own version of what they capture as overhead, and frankly, a lot of that time, a lot of that looks like stuff that might ought to be profit, and might ought to be something else. That's a tough issue on a lot of
it is. See it a lot. It comes up, you know, again, it's another fertile ground for litigation, as far as, you know, the pricing of the contract and what it may be. I don't know if there's really, you know, it's a very fact-specific analysis. You know, it's one of those things that you kind of get into, and, you know, I think every situation is going to be different, and I think, you know, every situation will be different, and you just got to wade your way through it as far as the arguments and, you know, trying to get it resolved. Those types of arguments come up, obviously, are discussed a lot at mediation. It always seems up they kind of, you know, again, I don't think a judge would allow that during your situation, but there always seems to be a workout in mediation. I've always encountered as far as how much, you know, their contractor's going to be paid for stuff like that. I had a mediation probably 5 years ago where that was the case. You know, it was a cost plus, and, you know, the hours worked, the contractor was working, and some other things was at issue. And so, I mean, obviously ended up just settling for, you know, probably somewhere in the middle. But, you know, I don't think a judge would allow it. I can't say always, but again, I think it's something that can be worked out through mediation a lot of times.
Well, in support of your view with that provision, there's at least one Tennessee case that I have cited, probably more than I should, but the quote in the case is, an estimate is just that,
Right.
an estimate.
Right.
And that's a great quote, because it's an acknowledgement that, like when I have contractor clients, I always tell them, don't ever say this is the budget. don't ever say that this is something, say it's an estimate, because at least you've got the argument, hey, that was our best guess when we put
Right.
this together.
Right, right.
So I've ran into this issue several times. I was wondering if anyone's litigated it all the way through, at least got really close to dealing with it. Is it just an estimate, and at what point does it become what looks like they purposely lowballed this person to get them to sign the contract? And then now you're looking at 70, 80% over what it was done, and we're talking let's say a residential client, and not Volkswagen. They don't have this unlimited bank resources to come in and say, okay, we can pay that because this price has increased. And I'm not talking about due to material increases or anything like that, but literally it just was way more expensive than what was estimated. And to the point where it really looks like there's some sort of negligence. And the only cases I've seen that deal with that are really more in property sales. So if you were to say, well, I'm selling you this 3-acre lot, turns out it's really a 1.5-acre lot. Now, you can get into all the why that happened, but there's a court case out there that says, well, you're talking, once you get to 50%, it's kind of presumptive that looks like fraud or misrepresentation. But I don't know if you've dealt with that in this estimate issue, because it comes up a lot.
I haven't, personally, I was trying to think. I know my partner, we had a situation, and I wasn't really involved, and I can't speak in great detail on it, but that situation did come up. It ended up settling, and we had a contractor client that come in. I do know that was owed probably, $10,000, $15,000. It's one of those things. A lot of times, sometimes you just tell your clients just to walk away because it's going to kick up a hornet's nest. Well, sure enough, you wanted to file suit to collect, the extra $15,000, $20,000, whatever it was, and they responded and counterclaimed, and a lot of it was based upon what you just mentioned. It was, that he was, given some estimates, and it ended up being, $75,000 more than what, for the house renovation. And he actually, he ended up paying some money to settle that case because some things came out in depositions that kind of shed some light on some of the things that he was doing. So I've never tried that, all the way through. I don't know how to judge that. One thing I was telling you about, the other one where I cut and pasted the cost, the fixed sums and the estimates. He was actually not a licensed contractor. I know Tim will probably get into this, and that our defense was going to be a lot of that was his profit overhead and what he can recover as being an unlicensed contractor. So that's probably going to be the major defense in that case, along with some of the ambiguities. I think somebody else had their hand up.
Yeah, I've tried that a couple of times.
Yeah.
And I do what that fellow said over there.
Yeah.
I want them to use my adjectives. And they'll start off using his.
Yeah.
But we get in that deposition and that trial long enough.
Yeah,
I
yeah.
use my adjectives long enough, they start using mine because they're the real ones.
Yeah,
And
yeah,
this is the
yeah.
contract price.
Yeah.
And then we start talking about operating pursuant to that contract price for the categories of work.
Yeah.
And then you've got this budget of $12,000.
Yeah,
And you got
yeah.
these materials and everything
Yeah.
and all that stuff. And so they'll start talking about how they're having trouble sticking to the contract price and for this category of work. So then, after they spend long enough
Right,
calling
right.
the contract price and and showing actions that reflect that being a contract price, and the judge has no problem holding them to that, because these guys are drafting the contracts, right?
Yeah. Well, to me, the worst thing, or the best thing, depending on what side you're on, that's happened recently for us is the Blue Cross Blue Shield case, where the Tennessee Supreme Court gave us this gigantic, law review article on what do we look at to determine what's in a contract, okay? And so they go 30 pages on that, and, the Cliff's Notes is, on the one side, is it the four corners, what you call the content, or is it what they were talking about, what they understood, the context? And so they go, if you've read if you can stay awake long enough, you've read the opinion, and you go through this whole thing, and then they get to the end of the opinion and say, well, Tennessee's never really been all content or all context. It's kind of a little of both. And so it's like, on any of those arguments, that's kind of where you are now. And I sure wish the court would have given us a little bit I don't want to criticize the court, but a better guidance. Because
There's mud.
it's hard,
Yeah.
but that's hanging over all of these issues
Mhm.
now.
Yeah.
You know, just makes me think, because I never pass up an opportunity to attack the legislature. But this presumption, the court's presumption that the legislature knew what they were doing when they wrote this.
Or knew the law.
Yeah.
They're presumed to have known the law. Oh, yeah?
When we know in reality, it's a lobbyist sticking something under somebody's nose.
Mhm.
Here, put this in, and that's what's great. Any of you ever been down at the sausage factory, which is the state capitol? March and April, and they're trying to get out of town, they haven't passed the budget yet, and that's when the lobbyists are down there sneaking in these little amendments to bills.
No, it don't start on caption bills
Oh,
versus the
yeah.
real bills.
Most of the folks in here, I think, they tend to be too. Jack Jones,
Oh, yeah.
he had a saying, well, the high school assistant for the legislature was out.
Or they say they put the inmates in charge of the asylum.
Payment, again, just a couple of things on payments for project here. You know, if you represent an owner, you may want the payments, you know, structured in accordance with, you know, their construction loan documents. Obviously, every bank is going to be different. There's some sample language here. That's obviously probably more for a fixed price type of scenario, and probably is more slanted towards, you know, a contractor. You know, I have a case going on right now. It was kind of interesting, and I mean, there's a lot going on with it, but I just got involved. But, you know, for whatever reason, you know, draws were made on this particular lake house, and about 90% of the draws have been taken for what was, you know, reported to be the contract price, and about only 50% of the house is completed. And so you guys probably see that a lot too. You know, I don't know if that's, you know, somebody from the bank not going out and doing their job. It's probably, you know, a little bit of everything. Probably some contractor misapplication of funds. That comes up quite a bit as well. So obviously, you know, if to the extent, you know, you can get the contractor to also control, or excuse me, the client owner to also control when those draws are going to be issued, you know, that would be of a benefit to the owner client as well. Home improvement contractors, I see this a lot. You know, a lot of times, and I've had some clients that come in and wanted to do this. They'll come in and they'll want to do a $60,000 reno project on the house, and they're going to, you know, want 40 or 50% of the money up front. And there's actually a contractor up in my neck of the woods that was doing a lot of this, and you know, he's being prosecuted by federal authorities and all that right now. But you're only allowed to take 1/3 up front on a home project. There is an exception to that. You know, if there's a, you know, payment performance bond, you know, and they've got a bond that's, you know, again, 1% of the net sales of the home improvement contractor's home improvement business. So just keep that in the back of your mind. I've had some contractor clients come in and want to take more than 1/3, and we kind of back that out for obvious reasons. Change orders, you know, we're going to hit this at a high level. Again, this is probably a topic that we could probably spend a day on as well. There probably should be some language in your agreement that kind of talks about change orders in some form or fashion. A lot of times it's going to say that, you know, a change order is only valid if it's in writing, signed by both parties, you know, so on and so forth. Change order is going to, make an adjustment to the original contract. You know, in the residential setting, come in many, you know, shapes and forms as far as what's being amended or changed. Obviously the change order should include, you know, project and, contact information. You know, you may have an owner that may have multiple projects going on. You know, it's hard to say, so make sure that your change order includes that, the day of the change, details of the change, obviously, what's being changed, and how that may affect the price and or, you know, the timeliness, whether it's going to extend the, you know, the job out. types of change orders, again, I've got some, I'm sure you probably all do as well, some contractor clients that are fantastic. I mean, they've got daily logs, I'll say, what happened on January 18th? They go to their daily logs and we did X, Y, and Z. We have these discussions, with an owner about, construction that was going on. And I've got some that, one, they don't do written change orders, or if they do, it's on the back of a napkin somewhere in some folder, or something like that. So, again, they can come in all shapes and sizes. Right here's a sample provision. I've tried to, from I guess a high level, just, basically state it should be in writing, but also the back half of that, it said that oral or unsigned change order shall be binding upon owner if owner fails to object in writing prior to substantial completion of the work performed in accordance with such oral or unsigned change order. And I think, oral change orders, even if you've got one that says it has to be signed and in writing, and I had this used against me one time. It was probably about $150,000 lawsuit. It was actually an arbitration, and one of the big issues was some flooring that was put in. It was, it was one of the larger ticket items, $20,000, $30,000 flooring adjustment. And my clients put the upgraded flooring in, and their response was, there's no change order for that. We didn't sign and agree to it. Therefore, we shouldn't have to pay it. And so these are some of the cases that I pulled. I think it's pretty clear that, the court's not going to let, in this case, an owner sit there and watch a $20,000 hardwood flooring installation go down and just stand by and then try to take the position later date we didn't sign a change order for it. So even though change orders should be in writing, I think there's some protection there. Again, very fact-specific analysis, but there's some case law out there that's going to protect, the contractor, for example, in that situation. A lot of contracts will have warranty provisions in them. Everybody's familiar with, the 12-month, new home warranty, whatever the case may be. Obviously, warranty, language specifies exactly what the builder must do and what the buyer should expect. I get a lot of clients that come in and, my 12-month warranty provision is running out and, we need to do something. And, more times than not, they've already provided notice under, the contract of things that they've alleged with the house and so on and so forth. And so, obviously, I think they're protected on that front. There is some case law that talks about this. This is a case from 2008. It really just talks about any time that a contractor enters into an agreement to construct a house, for example, that there's an implied duty or warranty of workmanship that goes along with that. So not only there's an express warranty, but you got the implied duty, implied warranty of workmanship that goes along. There's negligence claims that can be brought. I'm sure all of you are familiar with this. These are just basic statutes of limitation. Breach contract 6 years, damage to real property 3 years. If you've got a licensing issue, for example, that's a 1-year statute of limitation on the TCPA, obviously. I very seldom, there's case law out there talking about the gravamen complaint where it's breach of contract, damage to real property, so on and so forth. I don't even try to test that. I mean, if somebody's coming in, if I don't have a TCPA claim, I typically calendar it as 3 years from when the date of the contract was executed, even though it could even extend by that. So I think, probably the 3-year statute of limitation is, again, if you don't have a TCPA claim, what you really need to focus on. Statute of repose, again, probably all in here are familiar with this. It's 4 years from the substantial date of completion. I actually tried a case on this about 7 years ago. I had a client that had a very nice house, built a detached 3-car garage, and I think he had 2 Porsches in that detached 3-car garage, a couple Harley Davidson, so he had some nice, vehicles. Probably, at least up where I live, and probably, East Tennessee in general, everything you build is built into the earth in some form or fashion, to a hill or something. Well, this particular contractor built this detached 3-car garage up against an embankment, and he built it with hollow masonry block. And so 4 years and 1 month to the day, 4 years and 1 month 1 month after the statute of repose passed, that whole back wall collapsed. On those vehicles, tremendous amount of damage. Of course, we filed a complaint, got popped with a motion to dismiss out of the gate, got past that. There's obviously a caveat here that talks about, fraud as an exception to the statute of repose. And we actually tried that case, and the judge, I don't remember exactly what he said, but his analysis was that, a contract is a set of promises. Contract, it actually had in there language that it was supposed to, the back, the walls of that garage were supposed to be reinforced with concrete and steel. And of course it was hollow. And so won the case. He was an unlicensed contractor, and on top of that too, he got popped with some punitive damages, appealed it up to the Court of Appeals. Court of Appeals pretty much affirmed the trial court's decision as well on
By
that.
the way, can I do a quick trivia question?
Sure.
He's mentioned AIA contracts. Here's my trivia question for you. Have the standard AIA contracts ever had a 1-year warranty provision? Nobody wants to touch that.
I've seen this, I believe the answer is technically no, that it's not actually in there. There's wording in it that implies it, but it's actually not in there. I may have read an article one time talking about it, that's the only reason I didn't.
Yeah, there's a well-known article called The Myth of the 1-Year AIA Warranty. You ought to look it up one time. What AIA contracts have is a 1-year, open quote, correction period, close quote. There's actually language in the A201 that says this is not a warranty. So.
Interesting. Yeah.
I'm kind of of the opinion that because of the prevalence of the AIA and that's generated this myth of the 1-year warranty, and that's the only warranty period that anyone even thinks about. So most residential people say, well, that's all they have to give me is a 1 year.
Yeah.
That's not necessarily true.
And the tie-in to the warranty, why it's very important for warranties, is if you look at the AIA commentaries, the reason they wrote their contracts that way is they're used in all 50 states. And they didn't want to come in and say what a warranty is where states' laws can be different. In general, they would say that a warranty extends to the limitations or repose, that's why it ties into warranty. That gets litigated.
And I read a case just the other day that was talking about how they can use warranty periods shorter than the limitations period in order to minimize their limitations periods and make them smaller. So I thought that was pretty clever.
Just makes me think, when I was getting back to these football coaches, college football coaches, they're always talking about, they don't have a contract yet, they're just working under a memorandum of understanding.
Well, Volkswagen started under an MOU.
Did it really?
If you, IDBs, almost every IDB project you'll ever see has a memorandum of understanding. Of course, it's in a notebook about this thick. It's got 1,000 documents in it, but it is an MOU.
Wow. Insurance, a lot of times you'll see insurance provisions. Contractors a lot of times will have the CGL policies, to prevent third-party claims for bodily injury and property damage. I've run into this situation a lot, and I'm not an insurance lawyer, so it's always frustrating to me, but a lot of times when I think, a contractor has a particular type of insurance, I can never, there's always some exclusion in the insurance policy, and I was looking through some stuff for this presentation, and it's like, there's a ton of articles. I'm licensed in North Carolina as well, and I was reading some stuff over there about, whether a construction defect is considered an occurrence under the CGL policy. They have to cover it. So a lot of times I get in these situations where, where I'll have, a contractor that I've sued, and then, there's always some reservations of rights defense, that I'm hearing from the other attorney as well, and, they may not have to pay, or, whatever the case may be. So, maybe something to look into if you're an owner, see if there's some sort of faulty workmanship endorsement that goes along with that CGL policy. Obviously workers' comp insurance. Builder's risk insurance, that's obviously something the owner can get. It's designed to provide construction sites against theft, vandalism, and natural disaster. I don't know if it's just me or it's Upper East Tennessee Justice. I'm not really sure, but I'm practicing for 20 years. In the past, probably 3 years, I've had 2 houses burned down during,
Gatlinburg.
yeah, I've had 2 houses burned down during the middle of property disputes. One it's going on, it's a lakefront property up in Johnson County. It was a contractor dispute, and there was a storm that night. There was no other damage to any of the surrounding houses, but miraculously, my client's house burned down. They had builder's risk insurance, so they were able to recoup that, rebuild their house, and they're kind of caught back up to where they were. Another situation wasn't a construction case, it was a property dispute, and it was a situation. There was no insurance on this, but it's an interesting story that part of the there was a dispute between heirs on some property, and the way the settlement agreement was structured, if we could repay them back by selling this particular property, then it was going to trigger some other things in the settlement agreement. Well, they had a closing scheduled like on a Thursday, for example. The house burnt down on a Wednesday night. And so luckily, the folks that wanted the property actually didn't care about the house. It was kind of dilapidated, but I think it was pretty clear that house burnt down because these other people didn't want these other provisions in the settlement agreement to trigger and to go into effect. But I don't know if I'm unlucky or I need to buy a lottery ticket. I'm not sure, but it's happened to me twice, again, in a fairly short period of time over the past couple of years. Again, sample provisions, you guys can read those as far as that, what to be included in the contract itself. And you can go in more detail with these, obviously. These are, again, very basic provisions. Types of default, your contract should have obviously some default language in here. The typical types that I see are, non-payment workmanship issues. Obviously, we're all familiar with the material breach doctrine. If the other party breaches and is substantial, it leaves the other party from performing under the contract. One thing to keep in mind, you guys, again, I'm preaching to the choir on this, just the right to cure. There's actually a statute for commercial projects. Really, I think it's defined as just commercial projects, although you can use it as a guidepost for residential projects. But there's a bunch of case law that have extended the right to cure, for residential projects as well. I actually kind of used this. It was a small case, but I had a hardwood flooring installer that was probably a $25,000 job, and they claimed some defects and some other things, and he wanted to go back out, inspect, and try to fix it and do whatever he could. They just shut him down. They didn't respond to texts. The owners didn't. They didn't allow him to go in and inspect, try to make changes. We get the mediation. I started pointing out the case law on this, and you got a pretty decent resolution for the client in that respect. So again, something to keep in the back of your mind. There is a right to cure. I tried to analyze and review cases on this about how much of a right to cure. I don't know if you guys have any experience on that. I think I can't find a bright line test, especially in the residential context. I think it really just depends upon, what are you trying to cure? I've got a client that's got water in the foundation right now and some of those issues that are going on. So I think that probably would be a shorter time period than some other things where it's just more cosmetic. But again, I haven't been able to find a bright line test as far as how much cure you have to give them, how much opportunities you have. With the foundation issue, we've allowed him to come out. He didn't fix it the first time. Then he wanted to fill up the foundation with concrete or something or another, the basement with concrete, like that was going to remediate the water issue. And that didn't even comport with anything that my experts were saying. So again, just something to keep in the back of your mind.
I did have to look at this recently, and you do, as on behalf of the owner, give the notice. Remember, the construction defect notice statute does not apply to residential construction.
Right.
A lot of people don't know that.
Right.
So it's not under that statute. You do have to give notice, but what you get back as to the cure and the timing it can't just be, yeah, we can fix this for $5,000 and we'll get back to you when we might be able to do that.
Right.
Because if
It's
you
got to be
get
something more
like
specific than
back,
that, yeah.
Then you can just say, okay, sayonara, I got somebody else gonna
Right.
fix it. But it does, you have to kind of fairly meet the substance of the issue.
Right.
With your.
Does it kind of follow the, the commercial statute? Sort of, okay.
Or, wait a second, it depends.
It depends.
And I really do think it is, and there's a couple of cases out there, because I have looked at this, because I regularly have residential clients that come and say, I don't trust this person whatsoever.
Right.
They've done such a bad job, my expectations are so low, I would never allow them to come touch my house ever again. Please don't tell me I have to do this. And there's some cases out there that kind of say, well, if
Yeah,
there's evidence,
right.
you completely lost all confidence.
Confidence,
there's
correct,
no way they're
yeah.
going to do that, but it's a gamble. You're
It
putting it in
is.
the hands of the court, to
Right.
make that decision. So it's
That's the
very fact
jackleg, the
specific.
jackleg defense.
Yeah.
This guy's a jackleg.
And that's the conundrum I always run into, because, I know the cases you're talking about, and, I had that issue come up with the foundation or the water issue, and it's like, how much notice, or how many opportunities do I got to give them to come out and fix this issue? And, again, we got to the point where he was just, his concrete guy told him something that was so far out in left field compared to what our structural expert had said, that at that point we were just like, okay, I think we have enough just to go ahead and terminate and, move on, so.
But on the commercial statute, I recently got a case dismissed on that exact statute. They actually kind of gave us kind of a half notice, but they actually didn't let us go out and look at it. They talked about it, sent some photos, and our folks said, well, we can fix it, we don't have to replace it. They said, no, never mind. They went ahead and fixed it themselves, filed suit. We turned around and said, well, statute said you had to give us written notice, and we had to go through this whole dance of 30 days and 10 days and reject, offer and stuff like that. And you have to, I said you have to assert that as part of your claim that you've met that. And the court granted our motion, dismissed it. Because at that point, it's not just delaying the inevitable, you can't go back and do the dance. And that was my argument, like, we can never go back and conduct our statutory, it actually says assessment, not inspection, assessment of the damages. So you can never meet your obligation to give us pre-suit notice under the statute. And,
That's interesting.
and the other attorney in that case was like, well, no one ever uses this. Everybody knows. I've actually filed 2 motions on it this year, and I think I'm gonna win the second one too. And it was the second one, someone you guys know very well, said, well, Paul, no one uses this. I said, well, I'm using it, because I have to. So it's a very.
Was the dismissal on the pleading requirement that he didn't assert it, or just the steps wasn't followed, or
Well,
both?
The way that I did it was, they talked about the notice in the case, and I did a Rule 12 motion, it wasn't a summary judgment. And I said, the notice that they talked about in the case, in their complaint, doesn't comply with the statute. So, and then I say that they had to affirmatively allege that they've complied with the statute. And then they also said, we fixed it now, and we can't, because they refused to do it. And I said, they've actually alleged that it's no longer capable of being complied with. And
Interesting.
The statute says it's dismissed, but then doesn't it say that you
Yes.
can go
No, it
and
says-
It says
refile?
abated, it says abated, and that's what they argue is abated, but then there's great case law that abate means, it means actually worse than dismiss, to act like it, to basically to demolish it as if it never existed. And so they can't go back and fix it. So I think it's only effective if if the owner has kind of taken the unwise step of correcting the stuff and altering it, and you can't go back and do the dance. And the statute is black and white. That's my
Right.
argument. Is I don't care if you say that we had notice of it, or we kind of knew about it. We were kind of involved. In my other one, we kind of knew about it, but we didn't know that they were pointing the gun at us as we were talking through the issues with them. And now my argument is, well, you should have given us the statutory notice, because they would have turned that in. They'd have hired counsel, and we would have looked at it better before you guys changed it all.
Send me your stuff on abatement.
Yeah, that's, yeah.
Yep. Yeah.
Is that an issue?
They could not remove the complaint, they were stopped.
In the first one, there's nothing they can do.
Yeah.
Now,
So they can try.
they are going to try, they barked about trying, but they're not going to.
They
I'll
couldn't
say that, she may prove me wrong, but I don't see it. The second one is a lot closer, but I think I like my chances. I've got a black and white statute.
Does that require substantial compliance with it, or is it strict? Does it say in the statute? I just don't.
It doesn't say it, doesn't say.
The case also substantial, I think it's substantial.
No, there's only one case on it, and the case actually just reversed trial court because it was a commercial, it was a residential case.
Yeah, which it did.
But the case says, the statute is clear and unambiguous, and it requires. And then it says, but
Mhm.
it's only in commercial, not residential. So there's one case in Tennessee on that whole statute.
Wow,
Yeah.
that's the first time
Wow.
I've ever heard a court rule that a statute was clear and
It
unambiguous.
says.
Wow.
So,
Is the other party going to appeal that, you think, or is it already past that point?
well, yeah, no, I think they're gonna try to, it's Rule 12, so it's without prejudice, so
Oh, okay, they're going to go ahead.
they may try to fix it, but I can't
Yeah.
see
If they've already fixed the contract,
how they're gonna fix
how are
it.
they gonna fix
Yeah.
it?
Because I told them, I said, we're gonna do this dance again. If you refile it, we're gonna, because they did send me a notice after it was dismissed. And I told them, I said, that doesn't fix it. The same issue.
Still in for trying.
Rule 11.
I think I'm out of time, but there's just a couple other things in here, other provisions. Obviously, arbitration. Are you guys? I'm just curious. Prefer arbitration provisions for residential projects? I think there's pros and cons to it. I mean, I think know your courts, your judges. I'm fine trying. I've won every time I ever do a jury trial and construction case, but fine with bench trials up there. And obviously, what I don't like about the ADR provisions, and I got hammered on this. They've got those fast track procedures. And is it construction? Is it 100,000 two-party? Is that what it is?
AAA rule is not more than $100,000 claim of either party, not more than two parties.
Right.
And that goes under the fast track procedure.
Right, and I'm sure you guys have probably tried these things under the fast track. I got introduced to it in a commercial case last year and got hammered on it and he was counsel up in DC, he was representing a uniform supplier, a nationwide uniform supplier. I had a car dealership client and it was a uniform dispute and he intentionally pled it for like $74,999, and next thing I knew, we had the telephone conference, with the arbitrator, and he's like, okay, I'm going to set this for trial in 30 days. I'm just like, what? Obviously just an exchange of documents is all you get. No really written discovery, no depositions. It's almost kind of, trying to case like in General Sessions Court, but it's a bigger lick. If you got a smaller, even a medium-sized client, you can't, $75,000, $100,000 hit. That's substantial, and
The problem is, having served on fast track arbitrations as arbitrator, I don't know if this has happened to you or not, I bet it has. Lawyers go in and they don't get half their case done the first day.
right,
And
yeah,
then it goes over to the regular track rules, which is.
Yeah.
So, that's a warning if you're gonna do a fast track, you better get done in that day, otherwise you're gonna default to the regular track rules and have to pay money, some of us more. Yes, we're fine with that.
Well, that's all I had. I appreciate everybody's indulgence. I know it was kind of a basic contract review, but I appreciate it. So thank you.